So, since it's Holi, so let's me first wish you all a very happy Holi. And on this festive occasion, also, we are here together to update ourselves and just, maintain this kind of healthy bond between all of us, that we continue sharing knowledge on this platform. So, as the Women's Day is also approaching, so it was asked to me to share my experience being a women professional. So, basically, I'm from Jaipur, Rajasthan. So, I have done CACS and insolvency professional course. And along with that, various post certifications I have done, even in the artificial intelligence. I usually take up sessions on various platforms with respect to IBC, with respect to company law, and artificial intelligence and MSME startups, etc. Uh, my core field or my niche thing is basically MSME consultancy. So whatever government subsidies are there or whatever government schemes are there, I deal with that. Besides this IP assignments or no. So that is something which I do. So I have been working since my completion of my this professional courses. So it has been 18 years now. Um, Being a female, I won't say there is much of a difference if you are a professional. And because there is no demarcation what a male can do or what a female can do. So if you have the caliber, if you have the anxiety to learn more and more, and if you can approach people, that is something which might lack at times. So if you can, go around and just look for the opportunities, there are ample opportunities whether you are male or a female. So, since being, I've been brought up in Rajasthan, born and brought up in Rajasthan in Jaipur, and then I am right now working in Ajmer, where there is not much scope for this insolvency assignments, but still, uh, I somehow manage. So I won't say that in tier two, tier three cities we don't have opportunities. It is just a way we can proceed for it. It might happen that it may take time, but again, networking is very, very important. Whether it's male or female, for both, I will say this is the time wherein you can get more and more assignments just by having network. So how to engage with more and more professionals, that is something which you can learn and develop by engaging in various sessions which are conducted by various platforms. Maybe it is physical or through webinars. So first thing is you have to be updated, then only the work will flow to you. If you yourself are not eager to update your knowledge, then even if you have some assignment, you won't feel the confidence to do that, basically. So that is what I would like to say. So these sessions are basically designed in such a form with different different topics. Every time there is some new topic is allotted, and really the management team is really doing so great that they are even thinking out of the box, and they are thinking of these kind of topics. So sometimes it might seem that these are very theoretical, how to implement them practically, that becomes a challenge at times. So again, because my topic is also discussing the financial implications under the IBC. So we all understand that the whole IBC is created, or it is framed with the core concept of maximization of the value. So even if we are, in the core of our minds, that perspective should be there, that the maximization of the value is the underlying thing which we all have to work upon. So valuation is something we need to understand. We need to understand the financial implication of each and every assignment which we are doing. Whether we come from a finance background or not, sooner or later, these finances are the core thing for which either you can engage someone to help and understand. And nowadays, I will say that AI is reaching to the next level. We can, if we continue to use the artificial intelligence, then we can actually upgrade ourselves to our next level. So without wasting much time, I will first of all let you know what are the key concepts which we will be discussing upon, then what are the challenges which basically the insolvency professional faces, even though they know, they understand the financial implications, but still, we, some things are not in our hand. Everything we cannot control. So it might happen that even if the things are in front of us, we cannot do better in those scenarios. So the financial losses may happen at that point of time. So, what could be the mitigation strategies for that? So, we will be discussing that as well. And of course, we will be discussing some cases both ways. I mean, the success stories wherein the things happened within time frame, and the valuation, the value was maximized in those cases, and what was the strategies adopted by the insolvency professional therein in those cases. So that is the positive aspect, and the negative also we will see that where all an insolvency professional lagged, maybe because of his own negligence may be, or some other situations. So in both the scenarios, we will be able to finally understand what all what all are the precautions which any IP should take up in any of the assignments. So it will be a kind of, just a recap of whatever has happened in the IBC scenario so far, and what could be the takeaway for all of us whenever we are dealing with any kind of professional assignment. So with that, I'll just start sharing my screen. Just let me know if it is visible. So I hope my screen is visible. Yeah, so it's basically regarding decoding the financial implications. So, what do you mean by financial implications? In each and every assignment, we understand that it involves the financial part only, because the core thing on which this whole IBC revolves is, first of all, the corporate data should have made some default, right? So even uh, if we say that there is no default, there is no financial default, basically, then this won't go ahead. So first of all, when there is a default, that means the corporate debtor has failed to make the payments in time. Then in that case, the person, the financial creditor or the operational creditor, they have the right to file this application under IBC. So that is the threshold which we can say that that is the basic essential element for one to get into the IBC scenario. So when a default is made, so default is generally dealt in the financial terms only. So from that point itself, we understand the financial, the meaning of financials, or what is the meaning of finance with respect to these all assignments. So first of all, let us quickly understand whether IBC, or is IBC about resolution of the insolvency, or it is basically related to the redistribution of financial losses. So, what is your view on this? Since we have limited participants, I think we all can speak up. We can share our views to make it more interactive. Yeah, any one of you, is IBC about resolution of insolvency, or it is the redistribution of the financial losses? What is your take on that? Any one of you can unmute and you can speak up. Any one of you would like to speak here at this point of time? So being an IP, it's not just our role to, just quickly resolve the assignment. It is not basically talking about the resolution only. Being an IP, you have to step into various positions, various roles at various point of time. You have to keep the stakeholders at one platform so that it could be a win-win situation for everyone. So at the same time, when you are resolving insolvency, it is of course a kind of, sometimes it may seem that it is just a redistribution of the financial loss, because ultimately whatever we have seen during the whole journey of IBC, we have come across various cases wherein there has been a lot of haircut. So whatever a creditor is demanding, he is not getting the full amount. He is not recovering the full value. So a lot of haircut is there, but still that is being, taken up in a good way, because earlier maybe that kind of recovery was not happening, but nowadays the recovery percentage has increased. So sooner or later, I mean, this will evolve, and we are sooner to get the new amendments again in IBC. So various things will change accordingly. So our role is not just to, resolve this insolvency process, but our role is to also understand the key or the basic aspects which the other people want from us, or the stakeholders what they want from us. We have to gel with them, and we have to get into such a position that we can clear all the stuff as smoothly as possible. So let us understand the financial DNA of the IBC. So IBC operates on various parameters like capital structure correlation. So we have to understand what the capital structure is all about. Equity shares, preference shares, or debt, how much is it? We have to understand the core capital structure, how much loan is there. So all that we have to understand. Then second is the asset recovery, asset value discovery. So what all assets are there within the corporate debtor? Whether proper valuation has been done with respect to the assets, whether there is any asset which is not shown in the books. So how to figure out that? So all that is also a part of, this financial DNA. Next is the time value of money. So as delay happens, we all understand the value erodes. So as soon as we have the assignment, we should try to get it resolved within the time frame which is given. But normally it happens that we are not able to do the things because of some uncontrollable issue. But still, if we can make it out, then obviously we can have more value, because we could finish off the things within the time frame. Next is the risk allocation. The risk allocation is very important again, because sometimes it happens that there are some contingent liabilities also, which if you have not considered while doing the assignments, then in that case it might result into some kind of losses later on, or maybe the proper resolution, you will not be able to get a good or resolution plan. So proper risk allocation for various, maybe it could be, some litigations which you might not have thought of, that this kind of thing can also come up, or maybe some claims which you have ignored earlier. So you have to take care of the risks also which are associated with that particular assignment. Then obviously you have to pay attention to the creditor hierarchy. Creditor hierarchy simply is like who are the financial creditors. So making a proper distinguish between the operational creditor and the financial creditors, and the voting share, obviously. So if you have that kind of structure ready and you are thorough with that, then obviously the risk minimizes basically. So what all sections tell you about this financial DNA of IBC? So the core sections which are related to this is section 14, because it talks about the moratorium, and during that time frame we have a lot of, plus and minus both. So we will discuss that in detail later. Then in section 30 we talk about this resolution plan. Here again we have to check each and every parameter of each and every, I mean, resolution plan. Whatever you get, we have to evaluate it on the basis of the evaluation metrics which we have. Then we have to present it to the COC. So firstly we have to be very much confident that the resolution plan fulfills all the criteria, it fulfills all the relevant provisions of the code, etc. And then only we can proceed by showing it to the COC and all. Then next is the waterfall, that is section 53. It again tells you how that distribution mechanism has to be there. So again, finances are literally there at each level. Again, you have to understand how much to be distributed to whom and who will get a priority in that. Then section 29A obviously talks about the ineligibility. So whosoever is ineligible, even though they are giving a good maybe resolution plan, they will not be eligible or fit into that scenario. So sometimes we do not have to just rush for the figures. We do not have to just rush for the good financial uh, uh, plans or something like that. We also have to take care about the core thing which is there in the this IBC code itself, IBC itself, or the regulations. We have to follow each and everything, because wherever we are stuck, again, it will become a code of conduct issue for the insolvency professionals. So at every point of time, we must understand that we just do not have to see the financial impact of it, but again, on the other hand, we have to understand the whole and sole criteria or the overall perspective upon which a resolution plan or the things will evolve. So basically, we have to check the maximization of the value of the asset. That is the preamble. We all need to understand that ultimately the intention of IBC is to maximize the value of the assets. So this interpretation was again reinforced in this particular case of Swiss Ribbons Private Limited versus Union Bank of India. So bank is missing here. Supreme Court emphasized that IBC is beneficial legislation and it focuses on resolution over liquidation. So why financial understanding is crucial for IPs? Let us quickly understand that. So IPs have to understand the balance sheets, the figures which are made available to them, and sometimes or most of the time it happens that you do not have the proper records. Then again, you have to frame those records, maybe yourself or by engaging some experts for that. So again, when you have a perfect understanding of the balance sheets of the position, financial position of the company, then only you will be able to showcase it to the prospective resolution applicants, and thereby you can get the better value, or you can have the maximum value for your corporate debtor. So that is the case we need to understand. Okay. Next is to evaluate the viability for each and every resolution plan, or for each and every plan. You must be able to understand whether this will work out or not, whether it is viable or not. So from each and every aspect, for each and every parameter, you will have to check and you will have to evaluate, not only from the financial side but also on the other side, from the point of view of the stakeholders also. So obviously the financial aspect will hold the priority and the other factors will also come along. Third is to understand the haircut economics. So how much haircut can be easily taken up by the stakeholders? That is also something which you need to understand, how much they will be ready to accept in the particular resolution plan. So you have to understand the haircut economics. So what could be the best scenario for any of the stakeholders? Next is present the financial reality to the COC. So first of all, until and unless you yourself are not sure about the financials or the overall position, then how can you take that up to the COC? So first of all, it should be the IPs who should understand the financial parameters overall, and then they should be able to even present it to the COC in a better way. So nowadays, what we can do is a very small tip for everyone. Whatever balance sheets or whatever financials we have, what we can do is we can create a small dashboard with the use of various AI tools which are there, and it will give us a quick insight what all creditors are lying, or what all assets are lying, what all creditors are there maybe, and from there we can get a good perspective whether the position is can be taken to a going concern nature or otherwise. So all that can be checked by quickly getting the insights by using the AI tools also nowadays, and that is something which you can present to the COC, because everyone is not financial literate basically. So it is expected out of the IPs that they first understand and then they even present it to the other stakeholders, mostly the COC, so that they are able to make them understand that what is the exact position. Next is to structure the interim finance. We all understand the importance of interim finance, because if you want to continue the corporate entity during that time, you need some finance. So that is basically considered as the interim finance. So in order to have the interim finance is again a task. So how to get that? You have to, persuade various people, or maybe the creditors themselves, financial creditors. You can ask them to provide the interim finance. So you must do the calculation, then you must tell them that this is what you will get, and it will be considered, the cost of that finance will be considered as a part of CIRP, and you will be paid in priority. So again, how to structure that? First of all, how much interim finance you need. You cannot overestimate, you cannot underestimate. And again, you have to take the cost of it also. So proper structuring is very important, and that again requires your financial understanding. Next is to decide the liquidation versus resolution. So again, if everything is available on the record, then it is up to the decision of the IP how he wants to take it further, whether it will be beneficial to continue the resolution process, or it is, nothing is going to happen, it's just waste of time, so we can directly switch to liquidation. So ultimately, firstly, he should understand, then he has to take it to the COC to get the approvals and all, and then finally proceed for it. So for everything, he has to document, he has to make proper explanations. That is very important. So how he reached to that conclusion. So he has to make proper calculations and working to justify whatever decision has been taken. So without financial in-depth, procedural compliances becomes mechanical. So until and unless you understand each and every item which is there on the balance sheet or in the financial statements, then the whole process will be just mechanical, because you are the doctors of that entity which is under financial distress. So until and unless you understand the finances, the basis of it, you will not be able to cure that. So that is the whole concept. So let us understand again from the point of view of various stakeholders, what are the challenges faced during the whole process. So what are the financial challenges we will be talking about from the perspective of various stakeholders. So let us talk about the financial creditors. What is in their mind? What kind of challenges they might be having? So the first is core financial concerns they have, because sometimes they do not understand the financial things, so they will be dependent on others to make them understand. So the core financial statements which they are not able to read on their own, or maybe they cannot interpret it on their own, they will be needing the help of someone. So that is one of the challenges which they have. Then again, the recovery rate, that is also a challenge for them, because it's always like, whatever, if they go into IBC, they also know that they won't be able to recover the full value. Because the trend says that they will not be able to recover the full value. Some or the other haircuts will be there. So it is always a point of consideration, how much will be the recovery rate. Next is the haircut percentage. Next is the time value erosion, because the longer the process goes, the value erodes. We all understand that, and that is what the key concern of the financial creditors also. Next is the litigation uncertainty. At any point of time, litigation may come up from any of the other stakeholders. So there's always a consideration for this, or there's always a concern for this point also, that litigation could be, there could be some uncertain litigation possibilities, which might, take the process or drag the process longer, and it might erode the value. Next is the security enforcement limitations. So this can be, checked from this particular case. So after this case of Committee of Creditors of SR Steel India Limited versus Satish Kumar Gupta, the position has somehow changed. So commercial wisdom now dominates unless Section 32 is violated. 30 subsection 2 is violated. So the challenge is basically, are COCs properly evaluating NPV or only the headline numbers? So whether they are checking it in depth or not, that is whether they are checking the net present value of those assets, or whatever numbers are shown to them, or they are just going by the headline figures. They are not checking in depth. Basically, it should be our duty to make them aware that we should go by the present value of that thing. So net present value, we should all be able to make an assessment, and then we should showcase it to the financial creditors so that a proper decision can be taken. And if we get a good voting percentage in the first meeting itself, obviously the things will resolve in time. Next is operational creditors. They are often unsecured. They have very limited voting power. In that case, minimum liquidation value guarantee is there in their case, basically. So their basic challenge is commercial equity versus legal hierarchy. Next, if we talk about the home buyers, they are now recognized as financial creditors after 2018 amendment. So there's a very landmark case for them, JP Kingston Boulevard Apartment Welfare Association versus NBCC India Limited. However, there's still a challenge in those cases, that balancing project completion versus refund demands, how to cope up with these two things. So that is the basic challenge which they might be facing. Next is with respect to resolution professional. That is for us how or what are the challenges are there for all of us. So financial challenges here include cash flow management under moratorium. So we all understand that during the moratorium period, if you want to continue the entity as a going concern, then you need some cash, or you need some funds to manage that. So again, interim finance, then structuring the interim finance, how to take that from, and how to overall manage that, how to persuade the COC for all that. That is a cumbersome process. And again, you have to manage the whole cash flow. You have to create a proper accounting for all of that. So again, that is the challenge which the resolution professionals face during the moratorium. Next is verification of complex claims. Whatever claims are given by the operational creditors or financial creditors, in all the circumstances we have to verify that. So during verification also, it might happen that there are circumstances of some complex claims which are very difficult to understand, or maybe the calculation is difficult at times. So that is also a challenge for the resolution professionals. Next is contingent liabilities. If they are not properly incorporated in the reports, then obviously it leads to some kind of risk. So again, you have to check whether there are any kind of contingent liabilities and how to meet with that. Next is avoidance transaction. Nowadays, this has been a very, very important area for all of us, because for maximizing the value, again, there are very limited things which are available. So what you can do is, you cannot have control over the sale value of the asset. Whatever the other person is trying to pay you, you will have to take that only. But what you can do to maximize the value is, you can check for the forfeit transactions, whether there was any transaction which was preferential in nature, undervalued in nature, or any kind of avoidance transaction. So if at any point of time you come across with that, it is our duty to report that out, to identify and report that out, and you have to continue take steps to finally get that resolved, so that whatever recovery is taken, or whatever recovery is there, that can be distributed among the stakeholders. So that is why nowadays, for the maximization of the value, these avoidance transactions also play a key role. But again, within the time frame, since we have to manage all that, it becomes a kind of challenge for all of us. Next is asset preservation. Again, if you want to preserve the assets like machinery, then or whatever the building is there, if you just want to preserve those kind of things, then again you need some funds to do proper preservation, or you have to appoint someone to take care of those things. So again, that is also a financial challenge, because it again requires some of the other funds. Next is valuation disputes. Sometimes it happens that whatever valuation has been done is either overvalued, or overvaluation has been done, or maybe at times it is undervalued. So in both the scenarios, it is not advisable. So first of all, during the valuation, we have to understand that we have to get it done from the registered valuers only. That is the first thing. And second, for each class of assets, you should have different valuers. So, and again, for each set of class, you can have two valuations done. So it is very, very important that you engage proper valuers, and from the very beginning itself, you engage the valuation valuers to do the correct valuation for the entity. Next is with respect to the liquidators, what are the challenges? First is the asset deterioration, because the time, if it is taking more if to resolve the cases, then in that case, obviously the assets value will deteriorate. So how can a liquidator get good value, or how can he maximize the value? So that is always a challenge with the liquidators. Next is the title disputes. This generally happens because sometimes the assets are there in the book, but the ownership is not there with the entity, or it is not the proper documents are not being traced. So it is very difficult to sell out those assets in time. So that takes time, and thereby it erodes the value also. Next is secured creditor relinquishment decision. So the secured creditor, if he has relinquished his rights, then that has to be taken care while making the adjustments and in the waterfall mechanism also. Then again, it is a kind of challenge for the liquidators if that is not being correctly taken. Next is worksman dues priority. Again, you have to take care of that. Then the litigation cost. This could be a challenge because it might happen that there are a lot of litigations, and if you the lot of cost has piled up. So how to get that approved from the CO's final stake SCC, and finally to get it paid. So again, the litigation cost also has its own challenges. So liquidation recovery often we consider it is lesser than 20% in many sectors as per the IBBI trend and the reports which is suggested. Okay, so if we go further now, let us understand whether moratorium, as we were talking about the moratorium earlier, also section 14. So whether moratorium is a shield or a kind of sword, whether it helps the entity, whether it helps the resolution professional, or it is the other way around. So to understand this, let us have a detailed analysis whether the moratorium is a shield or it is a kind of sword. I hope my screen is visible. Is my screen visible?
Yes, ma'am.
Yes, madam.
Moratorium,
Yes, ma'am.
moratorium, whether it is a preserver or a destroyer of the value. We are understanding this thing. So some people might think, how can it be a destroyer of value? Yes, it may be a destroyer of the value also. So let us understand how it plays both the roles. So section 14, what it does is, section 14 of the IBC imposes a moratorium upon admission of CIRP, that we all understand. It basically prohibits, first, the institution of or the continuation of the suits or proceedings against the corporate debtor. Second, the enforcement of any kind of security interest. It again prohibits the recovery of property by the owner or the lessor. And again, it prohibits the transfer or disposal of the assets. So that is in favor sometimes, or most of the times maybe. However, it does not extend to personal guarantors as per the Supreme Court decisions. Again, it does not automatically invalidate the third party contracts. Again, it does not stop criminal proceedings unrelated to the recovery. So based on these facts, it might become, it might create some problem in some of the cases. Let us understand it further. Financial consequences from the moratorium, how and what can happen. So ultimately, here in this case, cash flow freezes. When moratorium starts, the secured creditors cannot enforce their security. Operational creditors cannot initiate recovery suits. Ongoing litigations is paused, and accounts are often get frozen in practical banking terms, though legally they are not automatic, obviously, but actually we cannot do any kind of transactions within that. So what is the financial impact? So the positive financial impact could be immediate liquidity pressure from enforcement stops. Next, there could not be any SARFAESI action. No asset seizure can happen during the moratorium. What can be the negative consequences of this? Suppliers may stop supply, customers may hesitate to pay, banks may restrict fresh funding, and again, there could be a negative aspect of trade credit that may collapse. So moratorium stabilizes legal position, but can destabilize the commercial confidence because the day-to-day vendors, they might not be happy with the situation. So the commercial confidence, ultimately, it gets distorted, or the customers are not very confident with the entity now. Second aspect, there is no enforcement of security interest. Section 14(1)(c) bars enforcement of security interest. Important Supreme Court ruling is Innovative Industry versus ICICI Bank here. The court has clarified in this particular case that once moratorium applies, enforcement mechanism like SARFAESI cannot proceed. IBC will override the inconsistent clause. So what is the financial consequence? Secured creditor lose immediate control, leverage, and this gives breathing space but removes the enforcement discipline. If we talk about the working capital squeeze, moratorium does not mean funding. Banks do not automatically extend working capital. Operational creditors, they really hesitate to supply. So this leads to shrinking operations, reduced turnover, loss of customers, and workforce attrition at times. So unless interim finance is arranged under Section 20, liquidity stress intensifies, and it is very difficult to operate in such situation. And ultimately, the burden is there on the IP to make it, sustainable or to continue the entity as a going concern. Next, asset value erosion risk. So if the business stops, or if the licenses lapse, or if the workforce leaves, or if the maintenance is not funded, then the asset value will erode rapidly. We all understand all these facts. Moratorium alone does not preserve the value. However, the operational continuity does. So basically, if there is moratorium, it will not be a guarantee that it will preserve the value, because until and unless we keep it in continuation form, we keep it operational, the value will erode. Some more judicial interpretations, some more case laws. So the first one is P. Mohanraj versus Shah brother. This is a Supreme Court judgment where the issue was whether criminal proceedings under Section 138 of the negotiable instrument continue during the moratorium. So this is a case of check bouncing. So it was held that proceedings against the corporate debtor are covered by the moratorium because there it is a criminal offense. So financial interpretation is it prevents check bounce prosecutions that could derail management during the CIRP. So positive impact here is it reduces coercive litigation pressure. However, the negative impact could be it may weaken the creditor's discipline. Next case is SBI versus V. Ramakrishnan. So this is again a Supreme Court case. Here it was held that moratorium does not extend to personal guarantors. What is the financial impact of that? Creditors can proceed against the guarantors even during CIRP. So this preserves creditor leverage and mitigates the moral hazards. Next case is Alchemist Asset Reconstruction versus Hotel Godwan. So here it was held that arbitration proceedings cannot continue during moratorium. What could be the financial impact? It prevents parallel adjudication that could distract CIRP. So what is the positive side of it? It centralizes resolution, and the negative side is it delays the dispute resolution. Next case is Gujarat Urja Vikas Nigam versus Amit Gupta. This is again the Supreme Court judgment. Here it was held that the termination of this PPA agreement. So this is basically the purchase agreement, public purchase agreement. So solely due to the insolvency can be restrained. Again, I'm reading this termination of a PPA solely due to insolvency can be restrained by NCLT if it is central to CIRP. So NCLT can take such kind of decision if it is beneficial for the CIRP overall. So financial impact is critical contracts cannot be terminated just because of CIRP has started. This is extremely important to understand, and it protects the enterprise value. Without this ruling, power plants would have collapsed immediately. Next case is Power Grid Corporation versus Jyoti Structure. So this is a high court case here. It was held here that bank guarantees can be invoked despite moratorium as they are independent contracts. So what is the financial consequences this particular case? Uh, the moratorium is not absolute. It balances creditors' rights as well. So let us understand quickly what are the pros and cons of Section 14. So the positive side is how moratorium preserves the value. So first of all, it stops asset dismemberment. So that is basically without moratorium, secured creditors enforce separately. Operational creditors can attach the goods. Landlords terminate the leases. Business collapse immediately. But due to moratorium, it prevents a race to the courthouse. So various cases will come to an halt because of this moratorium. Next, it provides a breathing space. The Supreme Court in innovative case has emphasized that IBC is meant to allow resolution and not recovery. Moratorium creates a calm period. This preserves the enterprise value if it is used properly. Next, it also prevents the value destroying litigation. So, Alchemist and Mohanraj cases, they show that they ensure no parallel suits can be filed if moratorium is there. So, this centralizes the resolution process. Next, it protects the critical contracts. Like in case of Gujarat Urja, we have seen that it ensures essential contracts will survive. So, without this, value destruction would have been immediate. So these were the positive aspects of moratorium, and now coming to the negative aspects, how moratorium can destroy the value at times. So first is a moral hazard. It could be a moral hazard. How debtor management may misuse time. There could not be there could be a circumstance that no enforcement pressure is there because you cannot pressurize the management or the IP to pay out quickly. No repayment discipline is there. So it might lead to a moral hazard kind of situation. Next is working capital collapse. Moratorium does not guarantee supply. Suppliers stop the deliveries. Banks hesitate to fund. Liquidity dries up and business may shrink at times. So during moratorium, until and unless you have the interim finance or any other steps to keep the entity going or to have the proper working capital in place, the moratorium will not be of any positive impact on you. Next is asset decay during delay. If CIRP exceeds 270 days, the machines will deteriorate, projects will stall, or the brand will erode. The brand value, obviously, the market sentiments are involved with that. So the brand value, whatever you have created over the period of time, it may erode. So moratorium becomes a value freezer in that case, and you cannot monetize that any longer. Next is creditor confidence damage. Creditors may tighten the credit across sector, increase risk premiums. They may even reduce the lending appetite. That may also happen. So this systematic cost is real. So does moratorium preserve or destroy the value? What can we say ultimately? So moratorium is a tool if it can preserve the value if the IP ensures operational continuity, if interim finance is secured, if the key contracts are protected, if the litigation is minimized, and if the process is completed within the time frame, or we can say quickly. Next, it can destroy the value. So moratorium can be a destroyer as well if the CIRP is delayed, there is no proper working capital in place, the business is already defunct, the IP is passive. That means simply the IP is not proactive in nature and he is not thinking in advance and taking steps, maybe. Next is if the asset preservation is totally ignored. So, if no steps are taken to preserve the assets, how will you get the maximum value of the assets? So, that is something which is on the negative side. So, ultimately, what is the overall economic analysis for us? Moratorium shifts the system from individual enforcement equilibrium to the collective resolution equilibrium. So, if coordination works, value shall be maximized. But if coordination fails, the value erosion will be magnified. So, what is the practical strategy for all the IPs? So, we should take care of this. First, to ensure moratorium preserves the value within 15 days, prepare cash flow survival plan. So, that is very important. How much cash do we require during the period of time, within the 15 days itself, you have to make a strategy. You can keep on, revising that, but for the timing, at least you must have that handy. Next is to secure interim finance as early as possible. Third is to retain the key employees so that you can keep the concern as going. Next is to immediately protect the critical contracts. Next, fifth point, to communicate with the suppliers so that the confidence is not lost, and they continue to have relations with the entity and they continue to supply. Next is to avoid unnecessary litigations. Next, seventh point is to push the COC to adhere to strict timelines. So again and again, you have to make COC aware that we have to finish everything in time that is there in the code. And if we delay the process, because at times it may happen that they do not vote, or they do not properly, in fact, they do not attend the meeting. Sometimes it may happen that the process is overall delayed. We might not get consent from them for various things. So we have to make them understand the provisions of the code. And again, we have to emphasize the fact that as much as we delay the process, the valuation will obviously erode, or it will keep on declining. So if you want a better value, better to sit and resolve, and better to understand everything and discuss and finally vote for the whole thing. So that is it for the moratorium aspect. Let's go back to the next topic. So what are the various challenges? I'll just make a summary of it. So firstly, moratorium cash flow, that could be a problem, and how to resolve that. Interim finance and the supply talks with the supplier will be able to resolve that matter. Next is complex claims, how you can handle those. So proper reconciliation or the counsel support can be taken. So experts view can be taken how to handle the complex claims. So if you are not able to properly make out whether the claim is correct or not, the calculations you're not able to check, or whatever, there are various interlinkages, maybe holding company, subsidiary company, and like that. So in that case, you can always take a expert advice. Next is regarding the contingent liability, and reading just the first column and the last column. So with respect to the contingent liability, you can opt for this probabilistic forecasting method. So this is basically, forecasting, or you firstly you identify what all probable situations could happen. So in the worst scenario, what could be our liability? So if you can just forecast it beforehand, that will obviously save you from a lot of litigations. Next is avoidance transactions. For avoidance transactions, the best thing is to file as early as possible. But at the time of filing, you should have proper supporting. Otherwise, the applications will be rejected, and it has happened in various cases. So for all the PUFE transactions, whatever you think, if you have identified any kind of PUFE transaction, then you should always make it a point to have a proper evidence for that. And you have to submit that along with the application so that it finally, it can be accepted, and again, the procedure can go on and you can finally recover the amount. Next is with respect to the asset preservation. You can always go for the insurance and security operations. You can secure the operations that way. Next is regarding the valuation disputes. A triangulated valuation approach should be involved. So better to have different valuers for different class of assets, and all of them, first of all, should be registered valuers, because it has happened in many of the cases that if the valuation is not done by the proper registered valuer, then that valuation report is not acceptable. So obviously it will not give a good impression also in front of the resolution applicants and the other stakeholders, to the other stakeholders as well. Next is asset deterioration. If this is a kind of challenge you are facing, then how to go about it? You should try and keep the entity as, you should try to have an going concern sale method. You can adopt this kind of strategy. If the assets are deteriorating, you can have it on as a going concern sale. Next is title disputes. With respect to the title disputes, again, you have to go for the title audit. You have to engage someone, or maybe if you can do it on your own, you should try and get the ownership documents whose asset is there basically, and whether the ownership is there with you. Until unless you have the proper documents, will not be able to sell it out. And you can even check for the partial sales also. For some part, maybe you have the title. For the other part, if you do not have the title, then you can go for the partial sales method also. Next is to the if the challenge is with respect to the secured creditor relinquishment, then strategic choice would be the best option. If we go further, there are two more challenges mentioned. So it is just a summary of whatever cases have happened so far and how what that best practice can be adopted by various IPs. So with that, this chart is prepared. So regarding the workman dues, if there is any kind of challenge, again, the predictive modeling will be an effective solution for that. Then with respect to the litigation cost, the litigation triage should be adopted in that case. Basically, you can have a proper, calculations with yourself, how much that particular case may go long, how long that case can go, and what could be the effective, what could be the, ultimately, how much cost it may involve. Now let us talk about the current statistics, which are even shared by the IBBI. What is the position as of date with respect to the ongoing cases, with whether they are in CIRP or liquidation? How much time that is taking? Because again, if the process is delayed, the value will erode. We all understand the asset value will erode. So we all know it, that normally it is not in our hands. We might have filed the application, but the approval itself or the admission itself takes time. So this is the scenario which we can see here. It is about the corporate insolvency resolution process. The trend here shows, the trend here shows that we have started making the graph from the position as on March 2018 and till it is December 2025, we have taken the positions. So there are three bars, if you can see. The blue one shows how many cases were admitted. So in 2000, we will directly discuss the 2025 case. So as on December 2025, this last bar we will be discussing. So as on December 2025, the admitted cases are like 8,833. These are the total admitted CIRP cases, out of which how many have closed? So 6,954 cases have closed. And how many are ongoing? Just as per the statistics, I'm telling you, 1,879 cases are still going on. This is the position as on December 2025, and it is published by IBBI. If we further want to have a breakdown of that, so this is the detail of CIRP cases as on December 31st, 2025. So admitted cases are 8,833, out of which 6,954 have been closed. So closure could be because of, but they have been withdrawn under Section 12A. So 1,260 cases have been withdrawn so far. They have closed on appeal or review or settled maybe. So 1,366 cases have been closed because of appeal or review, or they might have been settled otherwise. In 1,376 cases, the resolution plan has been approved and the liquidation order has been passed in rest of the cases, that is 2,952, and the remaining cases ongoing CIRP, that is 1,879 cases are still going on. So if we talk about the mode of closure in CIRP, we will find two kinds of things. One is either it has gone into liquidation, so that makes up 42% of the cases which were admitted in CIRP, they have gone into liquidation. And 58% of the cases are either resolved or are into appeal or review or settled, or they are withdrawn. Next, this table here shows that who had initiated this CIRPs. So whether it was initiated by financial creditor or operational creditor or the corporate debtor himself, that is under Section 10 application. and this last column is the financial service providers. So again, the status of CIRP, here we can see the total column. If you see, I'll just use the annotations. Yeah, so the total figure here again is the same, 8,833 were the total cases, and the breakup as per the applications file. So whether it was Section 7 application or Section 9 application or Section 10 application, it has been bifurcated that way. And again, out of the applications given by them, how much have been closed or withdrawn, that kind of thing is mentioned here. Then how much they have yielded in a percentage manner, it has been showcased here. So average time taken for the closure, I'm on this point, average time taken for the closure of CIRP, it is mentioned in case of financial creditor, it is taking 745 days. This is the average time taken. So you can very well imagine, obviously the value of the assets would have eroded by that time. Most of the value would have eroded by that time. In the case of operational creditors, it is again taking 751 days around. So on an average, if we see, it is obviously more than 700 days to close the CIRP process altogether. And if we talk about how much percentage claim it has yielded, so CIRP yielding liquidation. So how much liquidation value as percentage of claims, the stakeholders, how much they have received. So it is 5.44% of the claim they have received. So, and average time taken for the order of liquidation is 533 days. So this is the whole structure. If you can just analyze, if you want to analyze it further, there are some more slides to it. So we can just go to the next slide to understand it in a more better way. So in a snapshot, we can say this much, that how many CIRPs have been closed. So around 78 or 79% of the CIRP applications admitted have been closed. CIRPs which have gone into liquidations are around 33.4% of the admitted cases. So basically, so CIRP has closed and it has gone into liquidation. It could be that way also. So average recovery under the resolution process is 31.63%. However, average recovery in the case of liquidation is 6.1%, and the average time to close the CIRP process is around 739 days. So CIRP outcomes, we can see here how many cases have been closed, how many are ongoing, and how many are under the liquidation process. So this is the bar graph chart for that. Next is how many CIRPs were initiated by, these financial creditor or operational creditor or CD wise. So basically that already we have discussed. What is the percentage recovery of the claims? Obviously, it will never be 100% recovery. There will be a lot of haircut, but in CIRP, on an average, if we say it is more than 30% or 33, 34% recovery is there if the case is resolved in the CIRP process itself. But if it goes to the liquidation, the recovery is, closer to 5 or 6%, or maybe even lesser than that. We will see the cases also. Next, the recovery percentage of claims, initiator wise, if you want to see for financial creditor, how much they have recovered. So broadly, they could recover around 30 to 33% mostly. In case of financial service provider, it is on a higher side. So if we talk about the number of days, it is more or less, around 700 days. So 739 to be very precise in case of financial creditors. Next, if we talk about the liquidation value and time reality check. So for the liquidation cases, we can see that the recovery percentage is very, very less, and the average number of days to finally liquidate or get the things finally completed, it is around, or in fact more than 500 days. If we talk about the ongoing CIRP cases, this is the current scenario. So 1,800 something cases are going on in CIRP. That is something we checked. So out of which we can check that 76% of the cases which are ongoing, they tend to be of more than 270 days. So they have already crossed their limit. So basically, that is the thing we want to understand, that this is why we are not able to actually achieve the maximum value, because these things are not happening within time. But again, everything is not in our control. We can only try from our side to maximize the value. So again, what all things we can pursue, or what we can take care of, so that we can finish off in time, because there are cases wherein the IPs could resolve within the time. So we will share the success stories as well. So that is why we need to understand, maybe we are lacking in some point or the other, or if we can check the other way also, we might get better valuation. So maybe some points sometimes we forget. So these kind of sessions basically refreshes our knowledge, that we can even check that aspect, we can even do that way. So this is something which we need to understand. So if we want to go ahead and again discuss the statistics with respect to the liquidation process. So if we talk about the last column, total cases for liquidation, how many cases were initiated till December 31st, 2005. So there are around 2,952 cases, and out of which we can see that how many are ongoing. So ongoing is 1,339. So this is the I mean, the real picture which we have as on date figures which we have, and how much value they have received, or how much is the recovery. If you see the total realization, so if the admitted claims were around, see, 2,98,000 something, the realization is just 11,000 something. So it is barely, I mean, 3-4% maybe, hardly. So that way, if a case is going into liquidation, it might not be able to recover, or it might not be able to get proper realizable value. So that is the thing we all know, but this is the scenario. And this is the position of the ongoing liquidation cases. Whatever liquidation cases are going on, from that or out of that, 68% of cases are going on for more than 2 years. So that is the situation for the liquidation process, obviously. So this is how the whole structure is there, and this complete data set is published by IBPI. Now let us understand whether litigation, whether it is of any kind of whether it impacts the finances or not, or whether it is a positive thing or a negative thing, how we can take up this litigation. So can we say that litigation is not the enemy? The better way to say it is that unmanaged litigation is basically the enemy. So, how do you take up that? So, to understand the situation, we will again check what is the analysis overall, with the point of view of the various cases which have happened so far. Whether what is the impact, what is the financial impact of litigation in all our cases. I hope my screen is visible. I've just changed the screen. Otherwise, it will seem that only I am
Yes,
speaking.
ma'am.
The others. Okay, thank you
Yes.
so much. Thank you, thank you. So, what is the impact of litigation? So, firstly, let us understand what types of litigation could be there in IBC, and at various stages, at what all stages these litigation can happen. So, basically, they are being divided into 5 zones. First is at the time of admission stage, we can have litigations. Then, during the claim verification stage, again, we may have disputes with respect to the claim verification itself. Then for the resolution plan, challenges could be there. So any person can challenge that this is not the correct resolution plan, or the resolution applicant himself is not fit to file this resolution plan, something like that. Next is avoidance transaction litigations. So avoidance transaction may have it may keep on going if you do not have the proper evidences in your hand. So again, that is very important to have proper evidences to showcase whether the transaction falls into the PUFE category, and how you actually figured that out. And if you really want to resolve the case, you should have proper supporting. That is what is meant here. Otherwise, the litigation cost will be incurred, and obviously COC never wants to delve into this kind of situation. So again, we have to pursue them, we have to make them aware that if at any point of time this materializes or we get a recovery out of it, it will benefit all the stakeholders. Next is liquidation stage disputes. So these are the various zones within which we can divide the litigations. So let us understand how the first situation itself will be dealt. So we have taken the examples of various cases here. So in the admission stage litigation, delay will obviously be a cost. So Innovative Industries versus ICICI Bank, this is a Supreme Court decision. The Supreme Court clarified that once default is established, admission must follow. The Supreme Court discouraged prolonged pre-admission litigation. So if everything is falling into place, the application is not having any kind of error and there is default and the default is established, then the application has to be admitted. You cannot delay. So it is for the NCLT that they cannot delay the process, they have to admit it. So that is what it is dealt here. What is the financial impact of this? Before this clarity was there, admission delays were very common. delay usually caused delay are usually caused delay basically they caused this asset erosion, further debt accumulation, operational collapse. We all know this kind of thing, but now clarity is there. So if your application itself does not have any kind of technical errors and you can easily establish the default, then in that case NCLT has to finally admit. They cannot keep on questioning or they cannot delay the process. So therefore, we can say that litigation at this point of time is not there anymore. So time value of money matters. We all understand that. If admission is delayed for 2 years, we are just taking an example that if the assets are worth 100 crores, then and if the process is delayed, the admission process itself is delayed for 2 years, then the depreciation, if we calculate the depreciation at the rate of 10% annually, the asset value which were originally of 100 cr will now be of only 81 crores. So the depreciation will keep on depleting the value of the assets, and the litigation cost will also be there. So around, suppose it is 19 cr, suppose if that kind of cost is incurred, then obviously it will erode the value. So litigation cost as well as the asset valuation cost, that will be there. So that could be the deterioration in the value, but now the things have settled in that respect. Next is moratorium related litigation. The case is Alchemist Asset Reconstruction versus Hotel Godawan. We have discussed that in earlier situation also. But here again, it has a relevance because it is related to the moratorium aspect only. So arbitration proceedings cannot continue after moratorium. So this was held in this particular case. So what is the financial impact of this particular case? The positive side, it said that it prevents parallel asset attachment. So other persons cannot attach the asset because it is under the IBC regime now. So parallel attachments cannot happen. It preserves the corporate debtor integrity. However, on the negative side, if we see, it delays the recovery of the legitimate receivables if the debtor was a claimant. And another negative side could be it stalls the resolution of disputes that could improve the asset value. So that could also be a situation that there might be some circumstances due to which asset value could have improved, and there is again a halt on those disputes, on those matters also. Next is P. Mohanraj versus Shah brother. Here again the check bouncing case is referred for the moratorium. I think we have already discussed that. I can go to the next one regarding guarantor and third party litigation. So SBI versus V. Ramakrishnan. This is again a Supreme Court case. Here it mentioned that moratorium does not extend to personal guarantors. What is the financial impact? This is extremely important financially because now creditors can proceed against the guarantors. They can recover parallelly, and their overall recovery rate is improved because of this decision. If moratorium extended to guarantors, the recovery pool would have shrinked. This judgment increased the financial discipline ultimately. Next, so litigation might be helpful. So in that particular scenario, it was. Next is resolution plan litigation. So this is where the financial consequences are most visible. First case here is K. Shashidhar versus Indian Overseas Bank. The court held that COC commercial wisdom is not justiciable. What is the financial impact of this particular case here is it reduces judicial interference in commercial decisions. If court re-evaluated viability of the plans, it would have delayed and delays would have increased and the bidders would have withdrawn. So this judgment has improved the financial certainty. So once again, if the COC has accepted something, then again you cannot challenge their commercial wisdom. So this was mentioned there, so that delay in the whole process can be settled there itself. So no more delays because of this kind of thing. Next, SR Steel versus Satish Kumar Gupta. This is again a landmark ruling. We all know this. So it was held in this case that COC commercial wisdom is the supreme. Distribution of waterfall flexibility is allowed. Equitable treatment does not mean equal treatment. So what is the financial impact ultimately here? It has increased the bidder confidence. It has reduced the litigation risk. It has accelerated the plan implementation. And fourthly, it has improved the recovery rates across the system. So after this SR Steel case, the plan approval timelines have been established. Next, the next kind of situation for the litigation could be the avoidance transaction situations. So in this case, basically, we will be discussing for these sections, section 43 to 51, which are basically evolving this preferential undervalued fraudulent transactions. Obviously, the other section is there, 66 and on. So again, Anjul Jain versus Axis Bank. What was held in this particular case? Here, Supreme Court clarified the parameters for preferential transactions. So nothing to look beyond that. If it is falling within that criteria, this will be categorized as preferential transactions. So what is the financial impact? If avoidance is successful, assets will claw back and the recovery pool will increase. So, but avoidance litigation often runs parallel to CIRP. So again, both the things have to run parallelly. You cannot ignore that because within the time you have to manage both the things. The CIRP process will also continue and the avoidance transaction will also go hand in hand. Next, so if there is any kind of delay, so delay impact, it could buyer's discount value. Delay impact here, the buyer's discount value, uncertainty over the asset ownership, distribution is postponed. So thus avoidance can increase value, but prolonged litigation can delay the monetization. So both the aspects we should keep in our mind, that unnecessary delay in these kind of cases, avoidance litigation, if there is a lot of delay, then obviously it will not, we will not be able to monetize that for the betterment of the stakeholders. Next, contract termination litigation. This has happened in Gujarat, Urja Vikas Nigam versus Amit Gupta. We have already discussed this earlier also. So termination of this purchase agreement solely due to the insolvency cannot be restrained. What was the financial impact here? This case preserved the enterprise value in power companies. Without this ruling, power plants would have lost the purchase agreements and that would have become a scrap asset. So let us take an example to understand this. So if the plant has the valuation, with this agreement, if the plant has the valuation of 500 crores, without this agreement, the scrap value of that plant itself is around 100 CR. So the valuation, you can see it has dropped down to just 20%. So that is why these litigations have helped to keep the value intact. So litigation here preserved 400 crore value, which is very, very crucial for any kind of, resolution. This is a clear example where litigation improved the financial outcome. So litigation can also be good in one way. Next, delay litigation and time value of money. So Arcelor Mittal versus Satish Kumar Gupta. Here, Supreme Court held that Section 29A interpretation clarified the eligibility, though necessary eligibility litigation delayed the resolution. So ultimately, firstly, it is the duty of the insolvency professional. He has to check whether the application which he has received, resolution application, whichever he has received, resolution plan basically. So whether the eligible person has submitted that or not. So again, Section 29A has to be thoroughly checked. Various agencies are there nowadays to check that whether it is fulfilling this Section 29A criteria or not. And again, you can also use various, artificial intelligence tools to identify, to set the linkages, and understand whether the proper person or the eligible person is only giving the resolution plans. So, what is the financial consequence in this particular scenario? Time overrun increases the CIRP cost. If CIRP extends from 270 to 900 days, then asset maintenance cost will keep on rising. Working capital will shrink, employee attrition will increase, interim finance will accumulate as the CIRP cost will also increase, obviously. So let us take a quick example to understand this. So if CIRP cost is around 10 CR initially, after 2 years of litigation on this matter, whether this is in the litigation of Section 29A litigation we are talking about. So if it extends to 2 years, uh, the uh, where the original CIRP cost was only 10 CR, the litigation cost has increased the overall CIRP cost to 35 CR. So ultimately, it is saying that the creditors will get a lower recovery because of these unnecessary litigation. So again, it is on our part to check and kind of avoid these kind of litigations. Next, liquidation stage litigations. Common disputes during the time of liquidation. What could be there? First is with respect to claim ranking, how you are creating the ranks or how you are prioritizing. Next is secured creditor relinquishment. That is a common kind of dispute. Next is workman dispute and the title disputes. So each litigation delays the distribution process overall. So if any of these situation is there, obviously any kind of litigation will delay the distribution until unless that litigation is resolved or that comes to an end, then obviously the distribution will be delayed till that point of time. So what is the effect of delay? If 100 crores were ready for the distribution, but the litigation has delayed the process for 2 more years, then in that case, we can assume that at 10% cost of capital, the NPV reduces to 82 crores. So here the creditors lose the real value which they could have realized. So this is the total thing. So when litigation, so what are the situations ultimately if we want to understand, if we want to summarize the whole thing? So what are the circumstances when litigation preserves the value? So litigation improves financial outcomes when, or these are the situations, it prevents illegal asset stripping. Second, it restrains termination of critical contracts. So in at these points, you should always go for litigation because that will indirectly help in maximizing the value. So these are the scenarios where it is expected of you to go into litigation and continue with the proceedings. That is what it is mentioned here. The third point, where the litigation improves the financial outcome is when it clarifies bidder eligibility. Next is it upholds COC commercial wisdom. Next is it recovers avoidance assets. So in all these five scenarios, it is mentioned that litigation is good to go ahead with. So on the examples which are referred, we have already discussed these cases. In what scenarios litigation destroys the value? So we can simply say that if you go into liquidation, ultimately unnecessary delay will happen and it will erode the value of the assets. So better not to get into the litigation phase. So litigation destroys financial outcomes when admission is delayed, resolution plan approval is delayed, endless appeals are filed, title disputes are unresolved, and tactical objections used to block the plan. So for all that, I mean, wherever you can engage some expert or you can get some expert advice, better to have that, keep everything documented. So whenever, even if there is a case filed, then you have proper documentation to resolve the matter within the time frame. Each month of delay reduces enterprise value. Empirical IBBI data consistently show that longer CIRP duration is equal to lower recovery percentage. So this is something we all understand at this point of time. Financial modeling impact. So let us quantify. There's an example if we can just read through that. Let us assume this scenario. The resolution process should have been completed within 270 days. The enterprise value at that point of time was 200 crores. CIRP cost was say 10 CR and the recovery was 190 CR. Scenario B, if the resolution had delayed for 2 years, then obviously the value will decline. The enterprise value declines to say 150 CR out of see earlier it was 200 and now it has reduced to 150. CIRP cost will keep on rising because of any kind of delay. Obviously, the CIRP cost will rise and the recovery will be lesser. So litigation cost has eroded around 75 crore of the value in totality. So what could be the strategic IP response to these litigations? So what we can do, what is the ultimate takeaway for all of us from all this topic we have discussed? So IPs must first of all identify litigation risk at day one itself. And it is not just that you will be able to do it on the day one. It might not happen that way also, but you should always keep a check or make it a habit to keep on identifying the possibilities of any kind of litigation. You should have it in your checklist that you have to do that. Next is set litigation probability metrics. So at on what date the case was filed and what is the current scenario. I mean, every time you should have that metrics ready so that whenever anyone asks you, or at least you should yourself know that this is what is happening in this particular case. If that is not being followed up, it is again your duty to follow up with the case. Next is to push early hearings for critical matters, avoid unnecessary appeals, encourage negotiated settlements. So again, if out of court settlements can happen, you should go for that. If mediation can be done, because nowadays again mediation has will hold good because there is some separate act for that. So rather than going into all this matter, why not to go for mediation? And also that is also something which we can try it out at our level. Keep COC informed or financial erosion per month. That is also we have to tell to them, because if you are not telling or if you are not keeping the COC informed, then again it might happen that they may say that this is a kind of professional misconduct on your part. You have not disclosed each and every fact to them. So again, you have to keep them informed. You have to get the costs approved by them. So that is something which you have to be ready with. The data you have to be ready with regarding the litigations and every other matter. And then you have to showcase and keep the COC informed. Next is systematic financial consequences. High litigation frequency causes bidder hesitation, higher risk premium, low plan value. So this is something which we all know. What is the final conclusion? So litigation under IBC is financially neutral only in theory. In reality, it is a value multiplier or value destroyer, depending on the speed, nature, strategic necessity, how the IP handles the overall situation, what is the judicial efficiency. That all is, that plays a very key role in all of that. So, what we may conclude here is that litigation that clarifies law preserves the value, litigation that delays resolution destroys the value. So, the difference lies between whether it resolves uncertainty or it creates something, some certain element into an uncertainty situation kind of. So that is what we meant here by the litigation. So first of all, we should have a proper understanding. If we are not having proper understanding of the whatever the matter is, again we can seek help from various people rather than going into the litigation altogether. And if litigation is required at all, if you think that will enhance the value, that is really necessary, then obviously you should go for it. But at any point of time, you have to keep the documents ready, and you have to inform the COC about the status of the litigation, which is there. Next, there are some case laws. We can take that up. If you want, we can have a break at this point of time for 5 minutes, and then we can proceed with the case laws. Is it okay with everyone?
Yes, ma'am.
Okay,
Yes, ma'am.
We will meet around 4 4 4 p.m. or 4:10 or 4:05, whatever you say, and 5 minutes or 10 minutes. We will meet at 4:05 then.
Cotton is okay.
Okay. So can we resume the session? Yeah, so before taking up the theory part, I think let us now take something which will actually be of very much interest to all of you, how we can use some AI tools to understand the financials, basically. So if you have any financial report and if you want to just have quick insights of it, how you can go about it. So what are the tools which you can use? So nowadays we can use ChatGPT, we can use Claude, Perplexity also for research purposes. So even though our topic is somewhat different, but again, when it comes to financial implication, again we all might not be very sound with the financials. We might not understand what is there in the financial report, or it may take time to understand. It is both ways. So suppose if you quickly want to understand how the things are, I'll quickly take an example wherein the report, we can even have the annual report which is there on the website of the companies, or we can take the data from MCA also. So you can just download the data from there, and then you can start analyzing it. So let us try something. Just allow me 1 minute. I'll open one of the features here, one of the AI tool, that is, uh, we will open it on ChatGPT as well as we will use it on Claude. So I think to gain back the interest, because otherwise it will be a very monotonous session. Only I am speaking and there is no response from the other side. So just to engage you all, let us try and do something with respect to the financials. Okay, so what we are trying to do, I'm just sharing my screen. I hope my screen is visible. My screen is visible or not, you'll have to say yes or no before I go ahead. Okay, thank you. Thank you so much, Rajesh sir. Thank you. So, first of all, whenever you are using any of these AI tools or LLMs, what you have to be sure of, the privacy matters. So, what is the personal data? Basically, the client information. You cannot just share it on public domain. So, first thing is how you can safeguard that your document is, I mean, safe enough to be analyzed on these AI tools, right? So how you can check that? Firstly, if you go to this settings option, so before trying anything, I'm just telling you what are the parameters you should be knowing of whenever you go into this setting option. If you can see on my screen, this is the setting option, right? So here in this setting option, you have the security option. So this security option says that you can keep your data under various security measures, like you can have password, because in office anyone can use that, or if the things are open in your system, anyone can use that. So again, you can make a password for yourself. Then you can even opt for this multi-factor authentication. So if you can just click on that, you will be able to use different or multi-factor authentications on the same thing. So I'm not doing that right now, but what you can do to even safeguard whatever research or whatever analysis you are doing, it should not be open for anyone to check. So you can apply this kind of factor authorizations, multi-factor authorizations. Again, when we go into the data controls, if you go on data controls, it is mentioned here, improve the model for everyone. So when it says improve the model for everyone, whatever you are uploading, whatever documents you are uploading here, whatever research you are doing, whatever, I mean, questions you are asking and whatever answers you are getting, everything is open for everyone on the web. It is open for it is being used by these models to further enhance their knowledge. So we don't want that. We don't want others to use that. So what we should try and do is we should uh, check it off. So we don't want others to use my information to improve the knowledge. For it should not be used by others. In simple words, it should not be used by others. Whatever I'm doing, it should remain for me only. It should not be used by others. So whenever you are using any of these tools like ChatGPT, Perplexity, Claude, anything, it has this system of data control wherein you can specify that this model should be used, the information, whatever you are putting there, should not be used by anyone else, right? So, this is one thing which we must be aware of. The second thing, what I would like to tell you is that there is an option of this PDF 24, if you have heard about it. So, whenever we try to convert our documents into PDF or we want to compress them, we either use I Love PDF or Small PDF or something like that. This is again one tool which you can use, PDF 24. It says that you can download it to your system itself. So, whatever earlier also what you were doing is you were uploading the information on the web to be used by anyone, because once you have uploaded the personal information, whatever documents you have uploaded, maybe unknowingly, unconsciously, you have you have allowed everyone to use them. It was there on the web, so anyone could fetch it out and can use that. But to be on a safer side now, because nowadays there will be a new act which will be implemented from 1st April itself, that is Data Protection Act, if you have heard of DPDP Act. So for that we need to have these personal informations not shared with others. So otherwise there will be a lot of penalties on the professionals if they are sharing the personal information. So what all is included in the personal information? Any document which has the identity of the person, so like the SIN number, the PAN number, the GST number, and if you are just putting those documents just like that, just even as to convert or maybe do any analysis out of it, this will be considered as leakage of personal information, and you can be penalized. So it's better to download this option which is available, PDF 24. And what all you can do here is you can either merge the documents, split the PDF, you can convert images into PDF, whatever you were doing earlier also. Now this whole thing will be saved on your system itself. So this is again a very important thing. And then we want to talk about this option, redact PDF. If you understand this redact PDF, what is it? It will mask the information. So if you want to upload any document of suppose an entity which is named as suppose XYZ Limited, so you don't want to show that name, but the figures are okay. I mean, you cannot make out anything seen from the figures. So we want to put the balance sheet, but we don't want to show the name. So what you can do is you can hide the name using this tool, that is redact PDF. So how you will do that? You will choose the file here and choose your PDF file, Word file, whatever it is. You can just choose it, and it will allow you to mask that file. So how it will be shown, I will just show you the direct file, how it is done or how it is actually visible. Just allow me 1 minute. So it gives you the option to mask the file basically. And whenever you are trying to use these tools, you have to take that road. You have to use these tools very cautiously. Just a second. Suppose I wanted an interpretation. Let me just know whether my screen is visible. Is it visible? Is it visible? Is it visible to all?
Yes, ma'am.
Okay, thank you so much. Thank you. So like this, you can just blacken the main or the personal data, and then you can upload this and get the analysis done. So I just wanted to check whether the computation done is correct or not. So I can even check that. So the prompt which I have to give, that has to be very specific, saying that it has to check the uh, uh, you know co- uh, check the document as per the provisions of the Income Tax Act, or as per the new provision, whatever you want. I mean, the detailed prompt has to be given, and then it will do the analysis for you. So rather than you checking up all the things, you can now use these AI tools. But the important thing is, while uploading any kind of documents to these platforms, you have to firstly turn off that mode, that is improve the model for everyone. You should always turn that off. That is first thing. The second thing is, whenever you are uploading any document, then you can mask them and then you can upload. So how the analysis can be done, let us do a live example for that. Just let me know if my screen is visible. I'll be doing it on both ChatGPT and Claude. I hope my screen is visible. So I'll be just attaching a file here, and I will ask it to do the analysis. Just a second. Suppose I have this annual report and I want to understand what is the situation of the entity. So how I will write the prompt, I will simply first ask it, assume yourself to be an insolvency professional. Firstly, we have to define the role, because it does not know how it has to read the document. Basically, it may give a general answer, but we want it to be very professional in giving you the answers. So firstly, we will tell the role which it has to adopt while giving the answers. So I'm just writing, assume yourself to be an insolvency professional. And I can even use this mic. If you think that it is very difficult to write the long prompt, what I can do is I can simply use the mic. I'll use that also in front of you. Just a second. I have attached a file. This is an annual report of the entity. I want you to make a comparative analysis of different years. Provide me the ratio about the entity, the KPIs, and report about the financial health of the company. Whether this company is having a lot of debts, whether it is stable to work as a going concern in near future. Provide proper reasoning for your reply. And you can even write whatever you want, whatever kind of analysis you want. And suppose you want the output to be in the form of a downloadable Word file, that also it will provide. So I will just write that also. Provide the output in downloadable Word file format. So since it is doing your work now, it is reading the documents on your behalf. It has mentioned what all it will be doing. So the scope of work from IP's lens, it has given you that, and it has given you the details, comparative analysis year on year. That is what it will be doing. So it is just mentioning that these are the key performance indicators. It will be showcasing the report, everything it will do on that case. So here it is saying that you do not need to do anything further. If you want an additional annexure for the PPT, even you can convert this into PPT. Now, what is lacking here is, here it is saying that you will receive a downloadable Word file. It is still working. It has not given me that right now. So it is still working. It will provide me the details. Here it is also saying that the sixth part will contain professional conclusion, that is the IP opinion, a reasoned conclusion on whether the entity is over leveraged, whether the debt is manageable or alarming, whether the company is financially stable to continue as a going concern in the future. And then again, it is saying one more thing, practical interpretation aligned with IBC section 4 and 10 indicators. So it will check that as well for us. It is still working. If it is not giving you the output in time, maybe you can again ask the downloadable file is not visible. So you can ask it again and it will give you the answers. It will give you all the ratios. It is saying that we will give you the comparative ratios also. So this is the report in Word format which we have got. Yes, it runs. So yes. So again, it is a free version. So in free versions, it may take some time, but again, because I've been using it since the morning, maybe it is again and again asking me because it is saying that you have hit the limit for the data analysis. So that is why it is not giving me, but otherwise it will give you a detailed format in this report. We can try it on other platform also. Just a second. I have applied the same prompt on this Claude, and I'm attaching the file again here. I also want a dashboard. Also provide me a dashboard. Understand at a glance. The plot takes a bit longer. So here it provides me the reply quickly. The message will exceed. Again, here it is saying that it has exceeded. So I'll have to I will show it to you in 5 or 10 minutes. I have some other platform also where I can post this and I can get the data. Meanwhile, we can continue with the PPT and backend this will work. So I guess that way it should not be a problem. Just a second. Until unless you have the paid version, a lot of things may come to a halt. But again, you have to choose wisely which option you want for subscription. So just a second, I will be, is my screen still visible?
Oh, madam.
Yeah, just a second. I had just stopped screen sharing and I am trying it on some other platform so that I can show you exactly. Just a second. Now it is working, so I will directly take you to the screen here where it is being done. Will it be allowed or not? I don't know. Again, it is saying that. Uh, Let me see if it is working. Otherwise, see, sometimes it might say, like here in my case, it is saying that it is a long document. So you can just extract some pages and then you can share. But it is happening in case where, because the free limit has expired for the day. Maybe that way it is saying. Otherwise, normally it accepts. So we will try it on some other platform backend. I will show it to you sometime later. Maybe at this point of time, we should again go back to the slides which we were discussing. Just a second, let me go back to the slides. Yeah, we will now discuss a CIRP success story. So, success story would simply mean that they could realize a very good amount, whatever the claims were there, full recovery kind of happened. So, here, if you see this case, Rai Homes Universal Private Limited, this is in the sector of real estate. Here, the CIRP commenced on 19th June 2019. The date of resolution plan approved, it was on 18th September 2025. The financial creditor initiated this kind of, he actually applied for this. So, Section 7 application, it is basically the admitted claims are 23.8 crores. The liquidation value is 2.96 crores. The fair value is this much. And the best part is this realizable value versus the fair value. It is saying that they could realize 227% of whatever was claimed. So you can see that the claim amount is 15.87. Total realized by the claimants was 15.87. However, that is what is more than the fair value. So this is what is dealt here. So basically, the business and CIRP chronology. Let us quickly understand how the whole case had evolved. So the Rai Homes Universal Private Limited was a construction company engaged in civil engineering and building projects. Its last annual filing was many years ago, suggesting the compliance-free CIRP. Next, it is saying that CIRP process timeline. The NCLT record shows that CIRP was admitted on 19 June. There were multiple procedural orders which followed it, including IRP and RP appointments and extension orders were also there. A resolution plan was initially rejected by the tribunal in the early application due to some legal objections, but eventually a valid plan was approved on 18 September 2025. So what you can see here is the CIRP was admitted in 2019, in June 2019, and final resolution has happened in September 2025, 18 September 2025. So it's around 6 years, in fact. So this long process reflects the reality that sometimes good plans take time to be finalized, vetted, and accepted. So even though it has taken so long, the realizable value is more. That is what is meant to be studied in this particular case. So sometimes delay may even be good. That is what this case talks about. Next is explaining the outcome numbers. So this is the liquidation value 2.96 CR, fair value is 6.97, and the realization to the claimants was 15.87 CR. So basically, the realization was more as we talk about. The amount distributed to the stakeholders was over 5 times the liquidation value estimate, meaning thereby the sale was not a scrap auction. Assets were sold at significantly higher value. Commercially viable bids were received in this case. Fair value is normally what professional valuers anticipate as realistic resale value under the normal conditions. But in this case, the actual realization was more than 2 times the fair value estimate. This indicates that it was better than expected market demand. Strategic buyer involvement was there, and the value discovery was beyond static valuation models. So why this case was a success, that is what we need to analyze it, and we can take that in a regular practice also. So first of all, title clarity and the asset regularization was there in this particular case. The main asset for a construction company, since this is a case of a construction company, the main asset for the construction company is always the land, project rights, RERA approved project portfolio. So, resolving any title issue and ensuring clean land records before marketing attracts much better bids than the piecemeal auctions. So, even a uh, even a preliminary order record reflects objections regarding the land development agreements, suggesting early resolution of title disputes before the final approval. Resolution plan structuring with business continuity. So, what their plan was, whatever they will do, it will be with the vision of continuity. So, Rai Homes resolution plan appears to have structured payments and asset transfers in a way that rewarded creditors more than bankruptcy liquidation models. Sales proceeds likely linked to future realization from completed projects, possibly phased handovers with profit sharing, larger upfront payments than liquidation bids. So, such structuring can significantly increase the realizable value beyond the static liquidation estimates. The next aspect was target marketing and strategic bidders. The significant realization suggests that IP and COC did not simply rely on the default auction portal, but what they might have gone a step further was this way. So, IP here might have likely identified the strategic real estate developers on its own, prepared detailed information memorandum, held site visits, buyer interactions, structured negotiations early. This is consistent with outcomes where competitive bidding significantly raises realization. So basically, they are moving one step further, taking efforts on their own and figuring out who can take up this deal. Next, handling objections and tribunal approvals well. So, multiple tribunal orders, including the one rejecting the initial plan, shows that the process was litigated and challenged. But the final approval plan overcame these objections, which indicates strong legal documentation and compliance by the RP. So, IP should normally what he has done and what we can replicate in our practice also to ensure Section 30, subsection 2 compliance is airtight. So we have to strict by that. We have to stay by that. Prepare supporting documentation for statutory dues. Address objections before plan submission. Provide implementation certainty, timelines, guarantees, etc. So this gives tribunal confidence to approve plans even after initial resistance. So, what is the tip for all of us to understand? So, this is how we can focus on our cases also. So, clean and strengthen the title before the before finally marketing the thing. So, before issuing EOI or IM, so before issuing finally the expression of interest or the information memorandum, firstly verify land titles thoroughly, resolve encumbrances with documentary evidences, if necessary, apply to tribunal preemptively to confirm the ownership clarity. Prepare a title pack for bidders. So why this is important? In case of real estate buyers, they demand certainty. They want unclear titles and they want clear title, sorry. If the title is not clear, it will reduce the value. So that is why we have to be proactive in our approach. Next, to develop an attractive information memorandum with business narrative. So nowadays, this can be easily done with these AI tools to make it more attractive. You can use that. I will show that in some time. Maybe it will require some time to reset its limits. An information memorandum that combines asset inventory, project completion status, regulatory approvals, clear liabilities, future cash flows is far more attractive than the one that simply lists the scrap value. So, what all can be presentable to the other person? So, just step into his shoes and think from his point of view what all could attract him. So, that way you have to present your information memorandum. So, IP should include RERA status, project timelines, cost to complete or the ROI for the bidder, marketing visuals, and town planning insights. So this increases the bidder confidence and willingness to pay. Next point would be targeted buyer list and active outreach. So passive public auctions yield low competition. Instead, what you should try to do is identify 20 to 30 relevant developers, local real estate player you should identify, then the housing financiaries, lend consolidators, etc. You can go ahead with that. Then you should send them a tailored information memorandum, hold question and answer sessions, offer discrete data room access. So more competition will mean higher price discovery. So you can target a set of people and then you can approach them directly in order to have better plans. Next, plan structuring and deferred payments. Instead of demanding lump sum, consider the upfront and last mile payments linked to the milestones, revenue sharing from the future sales, development profit sharing, earnouts on project completions. These structure often unlock higher enterprise values. Next is preemptive legal readiness. So resolving objections before the plan submission. Firstly, it is saying that statutory dues should be crystallized, intervention applications should be addressed proactively, compliance certificates should be collected well within the time. So, this reduces the risk of court rejection, which has also happened in this particular case. So, what are the lessons for all of us from here? First is the valuation estimates are not a destiny. So, fair value is just a guide. When you bring strategy into marketing and structuring, actual realization can far exceed the estimates. Next is early engagement and strategic outreach. This should happen and it should not be just passive auctions. So you should go beyond that. Next is so here what is recommended is to have an ongoing dialogue with strategic players before the auction increases. Information symmetry should be it will increase the information symmetry. So next is proper plan documentation reduces the legal drag. So meticulous compliance with section 30 subsection 2 plus the clear implementation roadmap makes the tribunal approval faster and more certain. So whatever is demanded at the side of the tribunal to approve the plan, so you have to work accordingly and document each and everything with you. Next, constructive plans get better results. So plans that shows continuity or higher business value and not just the asset disposal often unlock the superior recovery. So what is the final takeaway? Here we have to understand that it was not just a luck, it was a product of early strategic marketing, strong plan structuring, compliance with tribunal expectations, addressing objections proactively, and targeted buyer engagement. So again, if you have some case or assignment with respect to construction or real estate, then you can obviously take the example of this particular the case study which we have just discussed. So there are a lot more cases, but in every case you will not find the success story. There will be many wherein the realization is low. So we will discuss both the aspects. So let me again share my screen wherein some other cases for CIRP are discussed in detail. We are discussing these details just to analyze what best practices we can adopt, basically. Just a second. Okay, so these are the further CIRP case studies. So first case is Interdrill Asia Limited. Here you can see that it belongs to oil field or drilling sector. Let us see the CIRP snapshot here. The CIRP commenced on 22nd December 2022. The amount of admitted claims was 614 CR. Their liquidation value was just 19 CR around. Then fair value was 27 CR. The realizable value by the claimants was 24.38 CR. So it is just 4% of the claims admitted. And the realizable value versus the fair value, if you want to check that, it is around 89.52%. So what has went wrong in this case or how this could have been uh, put into better position, we are just analyzing that. So firstly, let us understand the background of this case. Interdrill Asia was an offshore drilling and related services, a high complex, highly specialized and commodity linked sector. These businesses rely on multi-year oil and gas contracts, high specialized drilling rigs, skilled workforce, high maintenance costs. By the time CIRP was admitted, the company had ceased the operation. So this was a defunct company at that point of time. Competitor consolidation was underway. Global cycle in offshore drilling was weak. So this context is critical because it is different from steel or any other real estate case. So firstly, you have to understand the industry perspective also. What is happening in the normal economy, the global or the domestic economy with respect to the particular industry with which we are assigned the case of. Next, why the financial result was low in this particular case. So this was already a defunct company before even filing the CIRP application. So once operations had stopped, equipment site was idle, so it led to deterioration. The skilled crew had already left. The supplier's confidence had already collapsed. The existing contracts were already terminated. So the value left was only because of the scrap value, or if you could realize anything from the piecemeal sales. So we can check the further points here. The high cost of idle assets. When the assets are not being used and they are left idle, obviously they will incur costs. So drilling rig required dock fees, preservation, maintenance, crew rotation, etc. So idle equipment sucks cash and scares the bidders. So it does not gives a good impression that it is lying idle, and it involves further cost. If any resolution applicant is interested also, he will see these aspects. Next is market mismatch. Only a handful of global operators buy drilling assets. Local bidders often don't bid under this case. So low bidder competition will obviously mean lower prices. So what went wrong if we check from the IP lens here? The key errors were not in compliance, but in the strategy that was used by the insolvency professional in this case. So there was no early assessment of the viability of the project. If he would have assessed that this is not a kind of going concern, he would have directly taken it into liquidation and could have resolved it earlier. No target group bidder mapping was done by the insolvency professional in this case. Asset preservation was not prioritized. No going concern dialogue with sector players was done by him. So essentially, the IP treated the case like a commodity auction instead of a strategic industrial sale. So, what could have been done by him? So, let us drill it down further and have a step-by-step analysis. How could he must have taken the situation? So, as soon as any professional insolvency professional gets an assignment from day 0 to day 7, so it is a strategy week-wise we are seeing here. In the first week itself, early sector reality check should be done. Appointment of sector consultant, because we might not have the sector specific knowledge. So either we appoint someone or we seek the guidance from some expert from that particular sector. Commission asset condition audit. So if we start that particular asset, if we start if we take into the operation, what will be the cost of it, or what all costs are involved. So commission asset conditioning audit should be there. Then model 60-day shutdown value erosion could be planned out. Then assess the preservation cost versus value retention. So these aspects could have been checked in the very beginning itself in order to maximize the value. So if assets deteriorates faster than the auction value can be realized, you must change the strategy here. Next, from next week itself till the end of the month, they are giving the strategy. This kind of strategy can be adopted. So demand preservation strategy, what does it say? Negotiate with the creditors to fund preservation costs. So again, interim finance, something like that you should have asked for. Enter into agreements with port authorities to reduce the dock fees. So that is again a proactive step which you could have gone further for. Layout detailed 90-day preservation plan. So that is also required in these kind of cases. So without strong preservation, liquidation value only drifts downwards. Next, for next month, what could have been the plan? Strategic buyer outreach. So once you have analyze the situation at your end. Now you seek the buyers or who could be the strategic buyer. So identify the buyers. That is the next step. Identify the global drilling operators. So just not restrict to the local ones, but also reach out to the global players. Maybe they are more interested. Map possible buyers in these areas, like in various countries. Then prepare industry ready information memorandum and offer the site visit also, so that gives more confidence to the people when you allow them to visit the site. This is not standard public auction marketing. You should not really, just focus on the auction marketing only, but you should extend it further. Next month plan could have been to explore the going concern options. Now, various possibilities could have been figured out, like lease out the rigs while selling, or you could have entered into the joint venture with a strategic player, rent to service providers, sell in clusters like that. So even in defunct cases, creative sales structures can raise the value. So what is the takeaway for us? So what mistakes were done and what could have been the correct action? So treating it as a commodity auction was not fair in this particular case. So we should have, or the insolvency professional should have treated it as an industrial sale. Waiting for the public bid was another mistake. So basically, he should have targeted industry outreach for that purpose. Next is he ignored the asset preservation altogether. Then the corrective option should have been he should have gone for the asset preservation. Next, not exploring the leases. So again, he should have considered the flexible transfer models also. Next case, so this was one of the cases which we have discussed, wherein a better option could have been possible. Second case is with respect to this Vibrant Buildwell Private Limited. This is again a construction or real estate case. Here we are seeing that it is again a success story, because here if you see directly, they could realize more than 100% uh, of their claims, basically. So they had admitted a claim of 92.5 crores, and the realizable value was more than that. So 93 CR, we can take the round of figure here. So that is what they could realize. So how did that happen? What strategy was adopted here by the insolvency professional? Let us just figure that out. So the background of this case is Vibrant Build Well appears to be a real estate construction entity, and ideally it is suited for the value discovery because land is typical long-term appreciating. I think we can leave this one. We can directly go for the second part. Buy realization value was high. So there was a competitive bidding in this case. So multiple serious bidders participated, likely due to the clear title documents again, the transparent data room and the good information memorandum, attractive location, and the asset mix structure which was given. And the competition increase price was another option which was there. Then next is effective asset packaging. Instead of selling land and equipment separately, assets were likely bundled. Buyers saw operational synergy in that, and this way it improved the realized value above the fair valuation. Talking about the market conditions, real estate markets, especially in good micro locations, either recovered or remained firm. This external factor improved the value ultimately. So what the IP did or could have done. So first thing here we have yes, what he should have done and what should he not have done. So both ways it is mentioned here. So even in real estate, many IPs fail because they treat the asset as separate sales slots. They do not engage with developer early, underestimate the statutory requirements. So, but here in this case, what was done was basically the title was clean, as we discussed in the earlier case also. Firstly, you have to check the title. If the titles are clear, then it increases the value, obviously. The title was clean and verified early. The information memorandum highlighted revenue potential, targeted outreach to strategic developers, managed pre-sale compliances. So that is what it was done. So this smart planning reflects pro level of the IP behavior. So next, what steps should be taken? So immediate title and regulatory audit should be conducted as soon as you have this kind of assignment with respect to any construction or real estate. So confirm the land ownership history, verify RERA registration wherever it is applicable, check the environmental clearances, align with municipal bodies. So that is what we have to do in these kind of cases, assignments. Next is data room setup. So digitize all the documents, include the covenants, contracts, approvals, provide the compliance certificates, and provide a kind of transparency to the bidders by keeping all that stuff at one place. Next is early targeted marketing. Instead of just e-auctions, send information memorandum to 20 to 30 developers. Hold bidder webinars, arrange site visit. This will build a kind of competition and it will obviously increase the value. Next is structured payment options. So if real estate sales stagnate, they offer staged payment. They offer deferred deposit bonds, escrow linked milestones. These increase the bidder comfort. So you can even change the payment options, how this can be structured. So that can also be done. So what can be impact or strategy and the impact for us? So early title audit, we all understand that. Second is targeted developer outreach. Structured payment terms can be identified. Then transparency is the best thing which we can all do, and the analytics also, because it reduces the litigation risk. Next case is with respect to KGS Sugar and Infra Corporation. So I've tried to take different sectors case so that we understand what all we can take as a takeaway of the session basically. So this is into the sugar and infrastructure sector. Here, if we see that the recovery was just 30% relative to the admitted claims, right? So what they have done, what is the case in this particular situation? Let us see that. So sugar industry basically has highly cyclical, because you cannot have the production keep on going round the year. So this is a cyclical business. Then government regulated also, because a lot of export quotas are there, subsidies are there, maybe, or MSPs also are there. Then season dependent, that we have already discussed. Then working capital is very heavy in this case. Assets here generally include the sugar mill machinery, land holdings, byproduct facilities. This mix can have latent value. So why realization was better than the fair value in this particular case? So let us see that realization exceeded the fair value, indicating the smart bid generation, strategic buyer involvement, value beyond the traditional valuation models. So this is not a coincidence. Again, this is a better marketing and stronger bidding facility. This was done. Next is possible IP actions that have worked here. So align auction timing with seasonality. So sugar stock and machinery are more marketable. So after crushing season, when the government releases favorable policy and before rebate announcements, that is the timing which they have used for the auction purpose. So aligning auction with the cyclical highs improve the bids. Next, broaden buyer universe. So sugar mills attract other sugar producers, ethanol producers, agro conglomerates, asset strata investors. So IP should likely reach out comprehensively rather than relying on general e-auction. So whom all it can be of interest. So that way you should proceed. That is what is mentioned here. So highlight the byproduct value also. So it is not just the sugar, which is the main product which you should highlight, but you should also highlight the byproduct, which could be of value to some of the prospective applicants. So ethanol, bagasse, or the molasses have separate value streams. So that also you should identify separately in the information memorandum. So by emphasizing this in the information memorandum, bidders value assets more. Right. So again, you have to think from the various perspectives, from various angles, how you can maximize the value overall. Next, the IP action for sugar or agro infra cases. Firstly, he should try and do the sector cycle analysis, prepare a monthly, quarterly sugar price chart, map the upcoming release scenarios, advise the COC on best timing windows. So seasonality here influences the bidder pricing strongly. So that strategy also you can have in if there is any business which is which has a particular cycle or a season based business if it is there. Then next is to prepare the competitive information memorandum. Byproduct revenue streams. It should include byproduct revenue streams. It should also include the historical production data, workforce retention plans, and the PPA details. Again, for the energy congestion, cogeneration. Next is targeted buyer outreach. So he should again prepare the list of top 10 sugar producers, top 10 ethanol firms because they might also be interested. Agro processing groups, he can even target to them. Then merchant buyers specializing in agro assets. So selectively information memorandum can be sent to them. So what could be the takeaway for all of us? First is to time the auction. You can again, this is very important to time the auction in case of any season business which is having any particular season. So byproduct value, this should be again included in the information memorandum. Then target who can be your audience or to reach out the right buyers. And then if there is some signal from the government, you should try and hit at that point of time so that you get the maximum value. Next cases with respect to a consumer durable or a manufacturing company. Here we can see that the realization value or the recovery rate is 23%, right? However, let us go through this case again. Whatever we can, get the summary out of it, it will be very helpful when we do our own assignments. So why moderately low recovery was there in this particular case? This is a case of SME manufacturing assets, often that depreciates very fast. So in case of small and medium enterprises, it happens that the manufacturing assets, whatever the assets or the machinery which they have, that depreciates very fast. So machinery specific to the product line, high relocation cost could be there. So buyer discounts that bid. Brand is likely not very significant. So you could not encash that brand value here. This is not a failure, but a common profile in case of a mid SME CIRPs. So what might have went wrong? First, machinery valued only at scrap here. So often IPs just list machines as scrap, but some buyers value intact lines higher. Operational lines could be recommissioned. So this is a missed opportunity. Sometimes, if you think clearly, or if you go think out of the box, then obviously you can catch these kind of opportunities. Next, something which he did wrong was weak buyer targeting. Generic public auction attracts price hunters and not operators. So basically, again, idea is to the whole idea is basically to get the targeted audience. You should not just rely on the auction, but you should also go for the specific uh, 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 target audience. Next is what he could have done: conduct operational feasibility. So he should have checked, does a competitor want to continue the production? If yes, it could be a going concern sale. Next, if there is someone, even if the brand is small, he could have combined all the assets and it would have added the value. Next, he could have approached the software or the industrial buyers, check if the adjacent industries can use the equipment. So what could be the pitfall or how it could be a better situation? So the scrap valuation was done only from his side. Rather, we could have used the use operator value method models. So what could be the better approach? Just not to consider the scrap value, but even if it could go into the operation cycle for any one of it, how you could have better uh, done that, or what valuation you would have taken. Public listing only. So target industry buyers, you should have taken that. Next, we have one more case here, but rather than this, I would like to go into something. which is for liquidation. These are all CIRP cases. I just wanted to discuss one liquidation case as well. So I'll be just moving again to another file. Let me just make it full screen. Yeah, so this is a case involving liquidation. So Bharti Defence and Infrastructure Limited. So this belongs to defense, shipbuilding, and heavy engineering. CIRP here was admitted on 2017, and final date of disclosure you can see it is 13th January 2025. So many years it has taken. Though the liquidation order was passed on 14 January 2019, still everything took time to finally close it down. And again, if you see here, the admitted claims were around 17,000 crores. The liquidation value was just 614 crores. The sale proceeds were 484 only. And then finally, the distribution was just 320 crores. So what is the background of this particular case? Bharti Defence and Infrastructure Limited, formerly a part of this Bharti Shipyard Group, was a large defense and shipbuilding company with major shipyard facilities across India. It operated in a capital intensive sector with long gestation, large liabilities, and fragmented assets. CIRP was initiated on 6th June 2017 based on a petition filed by the Edelweiss Asset Reconstruction Company Limited and other financial creditors after multiple defaults under the resolutions and loans post restructuring. The company owed several financial creditors in excess of this amount, a complex mix of working capital, term loans, and debenture holders. An interim resolution professional was appointed and later confirmed as the resolution professional in this particular case. So, what went wrong in the resolution phase itself? Despite several expression of interest and bids, only one resolution plan could be placed before COC. Resolution plan rejected by the tribunal. The COC approved one proposal in March 2018 with requisite voting majority. However, NCLT Mumbai bench rejected it on 14th January 2019 on the ground that the plan did not show realistic infusion of funds, failed to differentiate between employees and the workmen rights, did not clearly provide for the statutory dues and the comprehensive restructuring. So, what was the ultimate impact? Instead of moving to the implementation part, the company was directed into the liquidation. The single most value destroying event was the failure at the tribunal stage, not just the COC approval. So, what was the lesson from this case? So, before submitting a plan for the tribunal approval, IP must ensure plan rigorously whether it satisfies the provisions of Section 30, subsection 2, that is clear funding details, statutory compliance, employee settlement details, and practical implementation feasibility. So again, it is the duty of IP to check all these parameters. Creditor or the class objections. Multiple objections were filed by the stakeholders, including worker unions, stakeholders, minority constituents, leading to additional hearings and delays, increasing the time to liquidation order. That is why there's a lot of delay because of these objections. So, what was the final lesson for all of us? Basically, IP needs early stakeholder engagement, especially trade unions and statutory parties, before plan submission to reduce the adjournments and challenges. Let us talk about this liquidation phase. What problem has occurred here? So I'm just directly reading the last line. So the assets realized only 2 to 3% of the admitted claims. Now we need to understand why. Asset deterioration and time erosion is the first cause. Liquidation spanned from 2019 till 2025. So it is more than 6 years. During this long window, shipyard assets aged and they got rusted. Market for heavy ship assets weakened. Land and building faced title and regulatory complications. Long delays diminish the asset attractiveness. Delay causes value erosion. So, what could have been done basically in long asset life industries? Timing is very critical. So delay equals depreciation. We all understand, but sometimes the things are not in our control. But I mean, this is what is mentioned here. Obviously, uh, if that can be taken care, that can increase the value. Next is litigation delays around liquidation assets. So post liquidation, multiple claims and interventions caused secondary litigation. This could have been, strategically handled somewhat. So Union Bank claim dispute rejected. So it was rejected, then admitted as operational debt upon NCLT order. So again, the classification was not correct, or maybe the voting percentage would change, or voting category itself would change in this particular case. Lease rental or the asset disclaimer disputes under liquidation process regulations, employee workmen committee resistance to asset handovers. So each litigation layer increases the cost and delay, eroding the overall net estate value. Going concern disorder was also there in this particular case. The corporate debtor had multiple shipyards and movable and immovable assets that have value as ongoing businesses. For instance, the Mangalore shipyard was sold later in a private deal for around 75 crores, but because CIRP had collapsed earlier, the assets could not be marketed as a consolidated going concern. Instead, partial asset sales, scrap sales, auction cycles, fragmented selling yields lower prices. That was done in this case. So, what is the lesson for all of us? Whenever it is possible, market core assets as going concern to potential strategic investors early, even during CIRP, to preserve the value. Ultimately, we have to check whether it can be taken as a going concern to the potential strategic investors also. What could be the possible solutions in this particular scenario? First is the pre-planned tribunal readiness review. So before filing a resolution plan with the adjudicating authority, ensure full compliance with this particular section, section 30, subsection 2, regulation details also you have to check. Next, seek early legal opinion on viability and implementation feasibility. Build employee settlement strategy, especially for the union resistance. Then document statutory dues and contingencies explicitly. So this we understand. Otherwise, it will again cause a lot of delay. Stakeholder engagement roadmap. From day one itself, you should engage the stakeholders. So engage the trade unions, share implementation roadmap with the statutory authorities, preempt the objections by thorough documentation, provide clear communication to buyer groups. So again, communication gap should not be there. You should disclose each and everything to various stakeholders so that there is no possibility of any kind of litigation later on. So poor stakeholder preparation fuels a litigation that stalls the resolution or liquidation. So Bharati here saw multiple appeals from trade unions and shareholders since proper communication was not done with them. Strategic asset marketing. For heavy industries, prepare standalone asset valuation, offer going concern options to strategic bidders. You can even bundle the assets, like for example, you can bundle this plant, land, and the ongoing contracts, and then you can offer it. So fragmented or scrap selling basically erodes the value. The Mangalore yard, for example, shows private sale after CIRP could fetch some value. Litigation cost control. So how you could have control the litigation cost there. For that also some points are mentioned here. IP should reject weak litigations early. You should not involve for each and every case that you have to go for litigation. So wherever you are thinking that this is not making much sense, you can just reject that. Focus on high expected value recoveries. Use early settlement negotiations wherever viable. So in Bharti's case, multiplicity of litigations took place, whether it was through tax department for with respect to lease or works council, etc. They consume time and resources as well. Continuous arbitration and appeal battles add cost with the limited benefit. Next, they could have used the personal guarantor here and avoidance right also. So, although not publicly reported here, often in major cases like this, seek personal guarantee liquidation. So, you can try for that also. File timely preference undervalued transaction or the avoidance transactions. This expands the asset universe and increases the realization potential. So again, you should always look for the avoidance transactions that can obviously enhance the value. And if there is any scope of the personal guarantor, then that way also you can check it out. How can IP reduce the financial cuts? So let us summarize whatever we have studied so far. How can we help to increase the value, or how can we minimize the financial cuts here? So what can be the takeaway for us? First is early financial diagnostic. Firstly, you should be able to diagnose the financial situation early. So how you can do that? Immediately after admission, cash flow statement should be reconstructed. So from there you can get the funds, where the funds will move out. So outflow and inflow, both the things should be well constructed in front of you. You should be aware how it can be done, and if you are thinking that the funds are falling short, then you should go for this interim financing. Then forensic review. This also should be taken care at the beginning itself rather than waiting till the end. You can straight away go for the forensic review. Next is identify the revenue leakage if there are any. So again, you have to be very cautious. If there is any scope of revenue leakage, you can identify that. The next is assess the litigation exposure. So because these are the things which, if handled well, they can reduce the delay and they can reduce the cost also. So that is the thing. Next is intelligent interim finance structuring. So overall, how much interim finance will be required, uh, and from whom it should be taken, what could be the cost. So effective planning of that interim finance is a very crucial thing, and how to approach it to the creditors for that, basically. So that is the thing we must understand. So avoid excessive interest burden, first thing. Negotiate priority terms carefully. Align with the potential bidders. You can align with the bidders also for giving this interim finance. Next, improve the information memorandum quality. So rather than just doing just a formality, making that information memorandum, make it more lively, make it more appealing for the other party, so that they can really just by checking that information memorandum, you can basically have a lot of potential or the prospective resolution applicants. So how to improve that? Maybe you can involve, just like we discussed, we can include some kind of dashboards. We can include some historical data. We can include the titles, whether they are clear or not, whether we have the proper approvals from various authorities or not. What could be the potential with respect to your original main line of activity? Like in case of that sugar industry, we saw that we can highlight the sugar production as well as the byproduct case also. So that is something which we can apply in our cases, and we can improve the information memorandum quality. So comprehensive information memorandum, it includes the asset quality analysis, security register audit, litigation probability assessment, and the sector outlook altogether. So better the IM, better will be the bids. Competitive bidding strategy. Competitive bidding strategies. Let us understand that how this can be done. Staggered payment structuring, contingent payout models, performance linked consideration. So all this can be figured out. That will be an innovative step from the side of the IPs to engage various resolution applicants. Scenario modeling for COC. Let us have these kind of, there are three models which are explained here. First is the resolution NPV. Next is liquidation simulation, which is as per the section 53. The next is enforcement outside the IBC. So various kind of models should be prepared and presented to COC at the time of checking any resolution application. So we are obviously checking it on the parameters of evaluation metrics which is there, but again you should again ask them to check on these different scales. Like you can even make the NPV scenario, the resolution whatever plan you have received, you just convert that, how that will look like in case of, if we take the proper NPVs in that structure. In the case of liquidation, how it will be applicable, and otherwise, if we go beyond the IBC scenario, how it will look like. So let COC make informed decision. So they basically rely on you because, as told you earlier, they are not all financially literate. So we have to make them aware that this is how the whole thing looks like, and this is how it should be. I mean, you can just tell them that this looks better or the other one, or you should basically not try to tell your opinion. Rather, you should try to tell the pros and cons of each and every plan which you have in your hand. Next, to avoid delays, that is also one of the key takeaways for IPs. Normally, we try to, do everything within the timeline, but again, it is mentioned again and again that if you delay the process every 100 days, it will create a lot of cost to you. So every 100 days delay will finally reduce the enterprise value. It will increase the uncertainty discount, and therefore that is the uh, last part which we had to take, just the solutions which, or the takeaways for all of us, how we can help the the corporate debtor to finally resolve with maximum value. We can adopt various scenarios. Let me just quickly check once again, if you can just allow me, if whether the dashboard is prepared or not with that site. Just allow me 1 more minute. Maybe I can change the file. I can put a simple version and then we can try for it. So how can we analyze the whole situation? Just allow me 2 more minutes so that at least we can understand how it will look like. If any one of you has any doubt or you want to share your experience, then we are open for that. I mean, you can discuss that meanwhile also. Taking a simple Excel sheet, maybe that will help us to understand the situation better. Just a second. Just share the screen. And I think people have to change the prompt also based on the file which I'll be uploading. Let me try a simple one. Yes, it has now attached that. Earlier file was a bit heavy, so it was not attaching that. Maybe you can compress it and then you can give it here. Then also it would have worked. So here I'm saying, assume yourself to be an insolvency professional. I have attached a file. This is an annual report. Now I'm not giving an annual report, so I'll just change it. This is the balance sheet of, of the entity for various years. I want you to make a comparative analysis of different years. Provide me the ratio about the entity, the KPIs, and the report about the financial health of the company. Whether this company is having a lot of debts, right, at a glance. So even if you have any spelling mistakes or anything, there's nothing to bother about. It will take that up. It's okay. So like, if you can see it, it is working on it. It is reading the Excel file to understand the structure, and now it is running some command. It is getting the full data. I've just given the balance sheet part, but again, it can have a lot of data, whatever you put into it. I mean, uh, if there is any limit to it, it will give the error. Then accordingly, you can adjust, or you can just extract some pages and then you can file it. And if you have a paid version, obviously it will do well. So I had just given it the balance sheet. It will calculate the ratios also for me, and it will prepare the dashboard also. I've asked it to give me a Word file format for the final output. So that also it will do. It will take a few minutes. Meanwhile, I can also give it to the chat GPT so that we can compare how the two are different. Just a second. I hope I can extend for 2-3 minutes because that will be the time taken by the plot to give its output. That's it. I've given it to both Claude and ChatGPT. Let us see the results. Just a second. So ChatGPT has also started to analyze here also. It is still running. So here it has provided me in ChatGPT. I have got the results already. So we can see from here the word file analysis report is there. Let us see that. So this is the analysis report. Again, the figures are not coming properly. Maybe the linking was not proper in my file, but again, just look at the things what this AI tool can do. So it can make the comparisons. So comparative financial position, if you can clearly mention in the prompt itself to make it in tabular format, it will do that way also. Here we can see the observations which has been made by it. Debt to equity ratio indicates leverage positions higher than to suggest heavy dependence on the debt. Current ratio is above 1.5, which suggests the adequate liquidity. I had only given it the balance sheet, right? And it has computed as well as given with the reasoning that this is the scenario. Positive net profit margin and ROE indicates the operational efficiency. Consistent growth in assets with controlled liabilities support the going concern assumption. If liabilities are increasing disproportionately compared to assets and equity, solvency risk may arise. But in this case, obviously, it is not there. Otherwise, it would have reported. And if we see the other results, let us go back. This was not planned. I just thought to share this one. So just you'll have to bear with me. Just a second. The Claude has computed something. It's still running. It's taking time at my end. I mean, you people can try from your side maybe, but it has prepared something. It is unable to load the PDF file. It requires. It is showing some error. Maybe just because things were okay. It has given something here. Just a second. Financial health report. We can download it. We can see that. We have this dashboard also. Hopefully it works. Just a second. Some issue, I guess it's not opening. Yeah, so this is the report. If you can see, this is the report, the entire report. You can see. It has itself mentioned that it is prepared by some registered insolvency professional and it is strictly private and confidential. Then it has given the executive summary, comparative balance sheets. It has mentioned the values. Then what are the key observations? It has placed that. Then financial ratios, KPIs. It has given that also. In nutshell, also it will give you the summary if you want. So that is a detailed report it has given, and this part is scorecard whether this can be taken as a going concern or not. So debt to equity ratio, so it is saying that debt equity ratio, it looks healthy. Equity ratio, there is a caution for that since it's on a higher side that way. So various ratios are considered here. Then again, what else is discussed? Let us just see the headings. I just give it a small command, but again, a detailed command could be given if you want a detailed analysis, somewhat like that. So it has given you the conclusion. The entity appears conditionally viable as a going concern in the near term, 12 to 24 months. It does not exhibit signs of imminent insolvency and so on. And then risk metrics also it has given. Then professional disclaimer itself it has applied to that. And since I wanted it to be in a downloadable Word format, it is, I mean, no formatting I have to do in this case. So it is good to go. I can even insert the page numbers. I can insert the header. Suppose I can get the print on my letterhead or something like that. So I can use it that way, right? This is just one thing which we have got, and the other which I mentioned was the dashboard. I don't know whether I'll be able to showcase you that because that is having some problem in opening. Just a second. Mhm. I think dashboard we won't be able to see. Dashboard, it is having some problem in downloading. So I think let it be. You people can try from your side, and obviously you can have a good you can have a very good insight for the financial statements. If you want to understand something also, you can go about it and you can keep asking. So either of the platforms you can use that way. So that is it from my side. If anyone has any questions, we are open for that. Otherwise, it's time to wind up the session. Thank you all for patient hearing.
Thank you very much, ma'am, for giving your valuable time and sharing your thoughts and experience on the topic.
Thank you.
Thank you, ma'am. Thank you. It was very